This panel is a conversation on digital platform business models and biggest challenges and in the face of regulatory scrutiny, and also maybe a conversation of opportunities with the next president and Congress to advocate for good competition policy. So I'm very pleased to introduce our panelists today. Matt Schroers is Vice President for Law and Policy at the Computer and Communications Industry Association, where he represents and advises the association on domestic and international policy issues, including intellectual property, competition, and trade. He's also an adjunct professor at the Georgetown University Law Center. Michael Petricone is the Senior Vice President of Government and Regulatory Affairs at the Consumer Technology Association. Michael has been responsible for representing the industry's position before Congress and the FCC on critical issues such as digital television, broadband, privacy, and home recording rights. And Abigail Slater is the Internet Association's General Counsel. She previously served as an attorney advisor to FTC Commissioner Julie Brill, and earlier worked as a staff attorney in the FTC's Bureau of Competition, where she focused on merger reviews in the high-tech sector and worked on several litigated cases for the agency. So I want to start, again, with this idea that the EU is on the verge of bringing some big antitrust action against Google on search and Android and advertising. And how does everyone on this panel expect the U.S. Agencies to respond to those enforcement actions?
Well, I'll jump in right there on this. I'm hand it off. I think it's important to recognize that most of the complaints that are being raised have already been considered and rejected by U.S. regulators. In some cases, there's actually been not structural remedies, but settlement decisions that Google entered into with the FTC. Obviously, the nuts and bolts of the antitrust policy, I think, were pretty well covered in the previous panel. But in a lot of ways, I would say that these issues have been asked and answered. And it's probably a little more useful to look at more broadly the sort of transatlantic differences in competition policy. I think there is a lot of merit to the argument that U.S. Competition policy, among other policies, like our IP policy, our free speech policy, our policy for protecting intermediaries, has contributed to the growth and persistent success of the U.S. economy. And for that reason, we should think twice before second-guessing some of our the competition policy choices that have been made here. And I think in a lot of ways, I won't go so far as to call it carpetbagging, but the fact that these issues are being raised again in Europe is an example of second-guessing some of the successful policy choices we've made.
Sure, and I think it's important to put the issue in historical context, right? Because right now we're talking about Google. But if you look back over the last 10 years or so, you're talking about Microsoft, Apple, Facebook, Intel, Qualcomm, probably others, all who have suffered through these EU antitrust investigations, who have been forced to pay billions of dollars to settle these charges and continue doing business in Europe. Meanwhile, the continent has had a very difficult time producing major new technology companies. I'd ask the room, when is the last time you used a European-produced technology, aside from Spotify, which I love and use every day? But no, it's like serious question. Like, think about it. Think of the top 10, think of the top 20 technology companies in the world, and think about how many of them are European. I think you would have a very hard time, right? And that's not just coincidence. I think it's because, as Matt said, we make certain decisions and they make other decisions that are less productive. And I also think the Brexit vote is obviously complex, and there are a lot of explanations. But one of the explanations is I think that Europeans are sick of dealing with irrational laws and regulations from unaccountable bureaucrats in Brussels, right? I think they're sick of it. And these kind of antitrust investigations are part of that. I think Brexit was a reaction to it. And I think, certainly we're very much in favor of the free movement of people and goods and services across borders. And we're concerned about, I'm very sorry, and we're concerned about, British tech entrepreneurs who want to hire the hot new developer from Berlin. And I'm very concerned about the ability of my team, Liverpool, to hire the new striker from Spain. But I do think if there's one good thing that comes out of the whole Brexit situation, it's a kick in the teeth to these European regulators to make them come to their senses and make them realize that they need to be less regulatory and more accountable. And I think you've got to look at these antitrust investigations in that larger context.
Gail?
Thanks, Teddy, and thanks to the Capital Forum for having me. So I'm going to go level set and provide a little bit of wider economic context too, but I do want to get to the antitrust question, Teddy, and I'll do that in a bit. So just to echo what the others have said, so I represent the Internet Association. We don't want to be the US Internet Association. We want to be the Internet Association, and so we have members including Spotify, but honest to God, there are only EU headquartered member too. And so we want to see economic growth over there. We want internet platforms to be enabled over there. And we love all our children equally, whether they're for Google or against Google. But when we look at the growth of the internet industry in this country, so we surveyed last year and issued an economic impact study, and what we found was it's 6% of the GDP of this country is now the internet, right? Just the internet, and it's growing. It's growing exponentially. It accounts for 3 million jobs. It's all good stuff, and the trajectory is very positive. We want the same thing for Europe. They have slower growth. They have huge youth unemployment rates. In Spain, it's as high as 25%, I believe. And so we want the EU to see our members as what we previously described as vectors for growth in their economy. And what we mean by that is absent a European Google, we want European platforms, but absent that, we're asking the EU regulators to focus on the growth that is enabled by existing platforms, whether they're US or not. And that growth comes from small and medium-sized businesses trading on those platforms, on eBay, on Etsy, you name it. The numbers are high and growing there. And we also want the EU regulators to acknowledge that, transatlantic digitally enabled trade, bit of a tongue twister, is over 100 billion, either side, coming and going. It's over $100 billion annually. And we want EU regulators to recognize that disruptive internet entry is a win for consumers. Prices go down, quality goes up. We only need to look at the impact of sharing economy entry in the District of Columbia to know that from our own experience. So, to get to your antitrust question though, Teddy. So your question is about how US regulators would or will react to a negative decision coming out of Europe as it impacts Google. And of course, we know that the FTC previously looked at this question. I am intimately aware of what happened in that investigation. I worked on it as an advisor to one of the commissioners, so I need to be a little bit careful what I say here, but I'll speak generally. And so as I see it, there's a large focus, and we heard from the previous panel about the substantive differences in the law in the EU versus the US. Having put together investigations here and worked on investigations over there, I think the substantive law is not unimportant, but a big difference between the two regimes here and there is process. And the fact that the European investigation is still open, I think, is as much driven by process as the substantive differences in the law. And what I mean by that is the Commission has a process that's different from the FTC and the DOJ. They don't have to go before an Article 3 judge in the way that the US agencies do. And they can have an investigation that runs for years and years and years. They're not put on shot clocks. And there's not the pressure to conduct and complete investigations that you have in this country. And so the timelines look different. The end game is very different. The European Commission issues a decision at the end of an antitrust investigation, and they're given huge deference on appeal. The rebuttable presumption is that the Commission got it right, And then it's up for the defendants before the European Court of Justice or the Court of First Instance to prove that wrong. It's like almost the reverse of here. And so I think that is maybe more than a partial explanation for diverging outcomes. I've said I have to be a little bit careful because I don't want to talk too much about what I shouldn't be talking about, but I think process is a big variable here that may contribute to diverging outcomes.
So I just want to follow up on this question. So the EU comes out with some, neutrality proposal for Google on search so that Google can't favor its own content to the detriment of vertical search providers. Then comes out with something to allow, forbid Google from leveraging its monopoly in advertising to, keep out competition on advertising. This is bad for competition in what way? Why is that bad? Why is that the wrong answer?
There are a lot of premises built into that question there, which I think would probably need to go challenged before I could meaningfully give you an answer. But I guess, looking at some of the previous panels, you can sort of turn that upside down and ask, is it good for consumers if predatory lenders are getting getting the same access on a service as other lenders, right? I mean, one might say that sort of discrimination, to the extent that it's occurring, is actually valuable. In the end, I think where you have competing services, if you don't like the results that you're getting from one platform, you can go to another. And so the burden of proof is on the enforcer that's seeking to argue that there is something amiss wherein consumers are being harmed. One need not prove the absence of consumer harm to make an enforcement action. One has to prove that consumers are being harmed to do so. And on the procedural point that Abigail mentioned, it's much more effective under the European framework for competitors to complain about other competitors. Whereas, as I think the previous panel explained expertly, there's a much greater focus in the United States on consumer welfare and ensuring that consumers overall are not harmed by the action of entities in the marketplace, as opposed to competitor assessment. And I should point out that we have examples of U.S. antitrust law doing that. I mean, while there's all the talk about the death of U.S. antitrust law, we should remember that the DOJ successfully defended its case against the Apple, where Apple, according to the courts, coordinated price-fixing activity among ebook vendors, and the DOJ brought a case against that and succeeded, and the courts agreed. And just this morning, we're hearing that the DOJ is refusing to amend its standing consent decrees against the coordinated conduct by music publishers through the PROs. So I think there's a lot of examples that antitrust law is still being enforced.
If I think everything that Matt said about regulators being careful and the focus on consumer harm is important. It's especially important in the tech industry, simply because in the tech industry right now, we are in the golden age of disruption, right? Never before, I would say, in human history, in any industry, have we seen a situation where new market entrants with limited capital have the power to come in and upend incumbents in the marketplace, right? And if you look back through history, you'll get a sense of just how dynamic the tech industry is. You could say, look at Netscape, look at InfoSeek, look at who is the predecessor to Facebook? MySpace. But they were all like dominant, like strong, dominant companies in their time, in their space. You go back and research and look at like the hysteria when Time Warner acquired AOL, which was going to be this world-beating monopoly, which was going to shut down all competition, because technology changes and consumer preferences change. And Microsoft was a dominant player. They're a very dominant player in the desktop space, which they still are. But now, the desktop space is being rivaled by the mobile space. So the marketplace changes. And I think it's just very important not to have investigation or an approach which is based on some static way that the world works, right? Because these investigations, I think the Google one has been going on for, what, 10 years? And in that time, you are using every day, probably multiple times a day, technologies that did not exist like 3 years ago or 5 years ago. And in 3 years, you're going to be using multiple times a day technologies that you have never heard of today. And that's the dynamic of the tech industry. That's the way it is. And that makes it, and because of that, a heavy regulatory antitrust hand is very misfocused.
So to piggyback off Matt's discussion of the sort of competitor evidence versus customer evidence and the different weight that that carries over here versus over here, or over there rather. So I would say, sort of having been through the process a few times, look, I think there's the meme over here is that the Europeans only listen to competitors and then they bring a case based on that. I don't think that's strictly accurate. I think they do more of an investigation than that. But I do think there is a qualitative difference in the weight that's placed on competitor evidence, and that might be a variable that explains a different outcome too, right? In this country, the antitrust agencies are very unlikely to bring a case, whether it's a merger challenge or a Section 2 case, to district court absent competitor evidence, or customer evidence, I should say. Competitors can be good witnesses on certain facts. They can be good witnesses on elements of an antitrust case, such as entry. They can be good witnesses on market definition, particularly in bidding markets where they've been through a bid process and they know what the contours of a market look like from that first-hand experience. They're not the best witnesses on effects. But then again, you could argue nobody is. Competitive effects is a forward-looking thing. A lot of good litigators will say it's just rank speculation for anybody to be testifying on competitive effects. The most weight that's given on effects is to the economic expert on both sides of the case, usually. And so that's a difference over here versus over there. In the context of two-sided platforms, and it won't speak specifically to Google, there's a lot of two-sided platforms that rely on advertisers for revenue. In that context, advertisers are the customers. And I can tell you that in many cases that I've lived through, absent advertiser witnesses, declarations, testimony in those contexts, the context of a two-sided platform, where those customers are willing to testify to price increases post-merger or historically in a Section 2 case, the antitrust agencies are reluctant to bring challenges. That's just the name of the game. They don't want to go before a judge absent that kind of evidence. They feel the need to put, as I've heard one very talented antitrust trial lawyer, Rich Parker, who's known to, I'm sure, many of you in the room, as he puts it, they need to put humanity on the stand for the judge. And the way they do that is through customers who are willing to testify in open court.
And we had Senator Warren speak yesterday about antitrust, and there seems to be a bipartisan call for ramped up merger enforcement. Senator Blumenthal in a hearing recently called the U.S. merger policy a failure. Senator Lee and Hatch have also asked for stepped up antitrust enforcement, particularly regarding Google. What is going to happen in the U.S. following these bipartisan congressional requests for beefed up antitrust enforcement in the merger or other conduct space?
That's an interesting question, because a lot of our merger enforcement policy choices recently have favored, in my somewhat inexpert opinion, obtaining agreements from companies to conduct themselves in particular ways, when it's not necessarily clear that that remedy would be available through an antitrust case. And so instead of bringing a case to block a merger, or, for example, even in a variety of cases involving FTC enforcement outside of antitrust, like Section 5, for example, we're seeing the government take the certain gains of settlement decree or a competition settlement commitments from companies instead of risking everything on the uncertain outcome of an antitrust case, which, as everyone discussed, will take a long time. So, in a sense, you could say antitrust enforcers maybe have been playing it safe. That's to say, they're saying, okay, well, we can get net neutrality commitments out of broadband providers when they want to merge if we make that a condition. Right? We can get certain privacy and oversight commitments out of these guys for possible Section 5 violations when, if we brought a case against them, we might fail and get nothing years down the road. So if you actually have stepped up antitrust enforcement, you may wind up with the government getting nothing, bringing a case and finding out some period down the road that they lost. And then the sort of interjacent settlement option, which you would have had years ago, is gone. So I think there's actually a greater risk on long-term policy, which is that you lose immediate benefits of settlements, and you run the risk of losing cases and then not getting anything. And my personal view is the example I gave of net neutrality commitments from broadband providers was incredibly important in sustaining the sort of open ecosystem that we have on the internet, and was recently affirmed by the DC Court of Appeal. So you might see enforcers rolling the dice and losing.
Yeah, as Matt and Abigail mentioned, that the dynamism of the American tech markets, like the world-leading American tech markets, are due in part to choices, the right choices, I would argue, we have made in antitrust policy. So I would hope that any future antitrust policy would take into account the dynamism and competitiveness of tech markets, as they have, and especially focus on the welfare of the consumer, right? If you look at these tech products, what they're consistently doing is giving users these revolutionary new products and services at a very low cost or for free, right? In the last 24 hours, I've used Yelp, I've used Google, I used Uber to get over here this morning, I've used Pandora, and quite frankly, all of which upended markets by giving people more information at a lower cost, if not for free. And quite frankly, thinking back, I do not know what I would do without those things, right? I think the consumer, no, because you take them for granted, right? But if you remember, do you remember what DC was like before Uber or then Lyft? We represent them both. It was hell, you couldn't get from point A to point B. It was hellish. And now you just take it for granted, right? You call the car comes, and it's cheaper than a cab. I found myself, I was in Toronto unexpectedly and had to spend the night because the flight was canceled. I wanted to find a good restaurant before. What do you do? Well, I had Yelp, so it was easy, right? So these benefits are so manifest. And I think it's important that the consumer benefit is the primary focus for antitrust regulation. The one thing I would ask is businesses need certainty, right? And I think it is important when a business wants to merge, if the law be clear and the law be certain, and they know before they embark on this extraordinarily expensive process, they know whether or not what they're doing is legal or not, right? And we've had a couple of cases where companies were trying to merge and it was called off, but the permission was denied, and that's just wrong, right? Because businesses, they need to know, they need certainty, and under the law, that is only fair. So that would be my one emphasis, I think.
So a few things on calls for stepped-up antitrust enforcement. To your question, Teddy. So also, Michael makes a great point, which is the business certainty point it's a very relevant point for this panel in particular. So first of all, push back gently on the assumption that there is weakened antitrust enforcement. And I think what the antitrust agencies have done in their own defense over time, because this is not the first time this point has been made by Congress, is issue publicly available data on merger challenges, the settlements, number of investigations opened by them, and it's pretty open source. And I'm a great believer in data. I want to believe it doesn't lie. And so over time, what you find is there actually is between administrations, there's a relatively stable number of enforcement actions. The pendulum may swing a little bit this way, a little bit that way, but over time, which is welcome by business, the business certainty point, it's a relatively stable number. So I'd make that point and push back on the assumption a little bit. I think what people in Congress are looking at are the big ticket mergers that garner a lot of publicity, and so those are the data points that they're looking to, but they're a very small subset of the overall data. On the second point that I'd make, and again in defense of the antitrust agencies here, is in this town there's a great saying, personnel is policy. The antitrust agencies have finite resources. Antitrust trials are hugely expensive to put on. The antitrust agencies are always scrambling for resources. I know I've worked countless unpaid overtime hours doing litigation at the antitrust agencies. And so I know that to be a fact from my personal experience. It's also very expensive for them to hire expert economists to put on a trial. And so all of these are considerations that go into the mix when deciding whether or not to challenge a merger or to bring a Section 2 case. They're very, very expensive cases to put on, and sometimes, frankly, a settlement can be, just from an agency resource standpoint, a more efficient outcome. Not saying it's the right outcome, but it can be a more efficient outcome, and that's a consideration that people on the outside don't really see as much, but it's a very relevant consideration for the agencies. And then the final point I'd make is, because this is not the first time this point has been made, I would suggest to the agencies that they do maybe a little bit better PR explaining this. They issue reports, and the reports are put out there in the ether, but then there isn't much follow-up on the reasons why they've done that and much communication around that.
There have been a number of studies, and a lot of these studies were referenced yesterday on John Quokka came out with a study saying that, of all the mergers where the agencies settle and just broadly looking at mergers that are allowed to go through, prices have gone up on average somewhere between 7 and 10% afterwards. There were studies mentioned yesterday about small business formation being at historic lows. There were studies linking increased concentration to the huge gap in rich versus poor, the income gap. It seems like by any measurable metric, this policy that is being talked about right now, which is like the standard, the consumer welfare standard, is not working at all. I mean, it's just not actually having the intended result, which is, at the very least, it seems like the framework is very focused on lower prices, and it just seems that the evidence is overwhelming that that's not actually occurring. So 2 questions, just follow-ups. One is, where is it in the antitrust law that it says consumer welfare? And then secondly, what's the response to all this data coming out that these prices actually are going up?
So I missed a lot of yesterday's presentation, so I'm not specifically certain which studies you're referring to. But I will say that's a remarkable litany of sins to lay at the feet of antitrust policy. And more generally, just assuming that all those problems are substantiable, it's not clear to me, as the previous panel pointed out, that these are all problems that antitrust policy should be expected to solve. One of the things that I think as a lawyer I see a lot, and it's not just in antitrust policy, but also in intellectual property policy, is that potential plaintiffs gravitate towards areas of law that have pretty strong remedies. And the structural remedies available in antitrust, the very powerful civil penalties that are available in Europe are quite attractive. They have a sort of gravitational pull because other areas of law where claims or problems might be brought or vindicated don't have as robust remedies, and so you go where the remedies are. And so that's why you see people advising revenge porn victims to register copyrights in the photos that they have so they can file DMCA actions and get statutory damages for copyright takedowns, when I think everybody would agree that the solution to revenge porn is not copyright, but that's where the remedies are, and so that's where people are advising to go. And I sort of feel like, talking about problems with social inequality being resolved by antitrust enforcement suggests that there's something wrong there. Those issues may well be serious issues that we want resolved, but I wouldn't necessarily ask an antitrust lawyer to resolve them for you. And I'd also point out that to the extent we do have problems, inequality problems, and particularly in the area of small businesses, a lot of the online platforms that we're talking about are great equalizing forces. They lower costs of entry. They provide access to services that previously you'd need large amounts of capital to mount. You can far more easily start a small business today using online services, where before you'd have to hire new employees or retain expensive services that were previously only available to well-capitalized entities. And so that's why you can see people using web-based human resource providers, contract services for bookkeeping and so on to launch a small business, hosting their content in the cloud instead of having to buy and maintain a server on your premises, and so on and so on. All these services are equalizing, and they allow small businesses to get into the marketplace. And so recognizing that is happening, and that one would want to preserve that to promote small business enforcement, I think is a very important policy objective that we should maintain and prioritize, quite frankly.
Okay, also, I was not here yesterday, so the same disclaimer as Matt. But as Matt said, I just see a proliferation of examples where these new technology platforms are empowering individuals and small businesses and entrepreneurs. Almost too many examples to give. If you look at Yelp, a few nights ago, I found this amazing taco place in Shaw that I never would have found. Because it was like this hole-in-the-wall place. Were it not for Yelp, right? This was clearly like a restaurant with no marketing budget, because it was tiny. And I ate there, I found it through Yelp, I ate there, I loved it. Now I'm telling everybody about it, because then I reviewed it. But that's just one micro example. If you have a car, if you have a spare room, now you can become an entrepreneur. It was really interesting. I was in Paris recently, and as you know, they've been pushing back very heavily on Uber and Lyft. So of course I was determined to take Uber everywhere if we were going 10 feet. And so we'd call an Uber, and my wife thought I was crazy because we'd be going someplace, and I'd be like, we're taking Uber. She'd be like, there's a taxi stand 10 feet away. No, we're taking Uber. And every Uber that arrived was this impeccably clean, Renault or Citroën, driven by this impeccably dressed young North African immigrant. Right? And you could clearly see this was a population that has been excluded from a lot of opportunity in commerce, right? But finally, you have a technology, you have a platform where you don't have to go and ask for a loan, you don't have to go ask for a mortgage, you don't have to go ask to rent space. If you have a car, you can be an entrepreneur. And these people were doing it. They were taking that opportunity and seizing it. And it was great. And the same with Airbnb, and to jump to another platform. Now if you used to be, if you were a musician, if you were an independent artist, you had to go to a record label, and or if you were a video, if you had a good idea for a video, you had to convince some network or some cable station to pick you up, right? Which 90.999% of the time was not going to happen, and you're out of luck. Now, because of platforms like YouTube, you can just go and do it, and you can be a success, and you can monetize, right, in ways again that are unprecedented. So I'm not sure what the conversation was yesterday, but I see all kinds of wonderful and extraordinary examples of how these new platforms are empowering individuals and small businesses.
And Gail, I want you to answer that question as well. But again, also. Part of the question is where is consumer welfare, or this notion of consumer welfare, or the current people's interpretation of consumer welfare. Where is that in the law? Like, I've read over the antitrust laws a few times. Can't seem to find it. Curious, is it there? And what's your response to all the overwhelming data that prices are going up following antitrust divestitures and behavioral remedies and things like that?
So again, I haven't seen the Quokka study. I'd be interested what some of the audience, and maybe you have reviewed it, had time to review it, think of it. And I know that for every economist, there's a counter-economist. I mean, they live to fight one another over these issues, so I'll leave that to them. To your question about the law, look, we have old antitrust laws in this country, which is a good thing, right? But they are framework statutes. They've been around for more than a century. And so because they're framework statutes, they've been gap-filled, and they've been gap-filled by the antitrust agencies who issue guidance on these things. And I can tell you consumer welfare is absolutely baked into the modern guidelines that come out of the antitrust agencies. And similarly, with the case law, you see most judges, although they may not consider agency guidance to be hard law, they will follow the framework of the agency guidelines, particularly in the merger review context. We've seen that time and time again. And then on the issue of consumer welfare and sort of putting it on an antitrust case and winning an antitrust case, because if you're an antitrust agency, you want to bring it to win it, right? What they found over time is there is weight placed on that which can be measured, and that's price, right? I mean, that's just been their hard-won experience. And again, going back to the process point and to the resource point that I made earlier, it can be awfully hard for them to bring a case and win a case looking at non-price dimensions of competition, because they're considered squishy relative to the empiricism that you see on price competition. And that's just my 2 cents worth. Yeah.
I just wanted to say, I didn't mean to dodge your question on consumer welfare. And certainly I think Gail's answer, I wouldn't disagree with any of that. But, gloss that is added, gloss is often added to our statutes over the years through the precedent and appellate interpretation of that, and that's, I think, sort of the consumer welfare has been a strong example of that. Just I can point you to a lot of areas of the law where our guiding principles evolved through appellate decisions over the years that are sort of added on to the statute, and it's true that they're not necessarily in the underlying statutory language, right? Like incentives for authors and inventors isn't actually, for most part, hard-coded into Title 17 and 35, but they are sort of well established throughout the appellate decisions that interpret those.
Yeah. Do we have any questions in the audience? We got one from Sally here.
I actually meant to bring this issue up in our last panel, but you guys have touched on it as well, is this whole notion that everything that's provided to us, or most of the services that are provided from these tech platforms, is free. And I want to push back on this idea that it's free, because maybe we're not paying for it with dollars, but we're paying for it with our privacy, we're paying for it with our data. If Google would allow me to pay them a monthly charge to use their search engine, I would take that in a heartbeat over being tracked over everything that I'm doing. Or for using their map feature and not having my whereabouts constantly be known about when I'm taking an Uber or whatever. We're paying for it in other ways. And I guess in addition to, in terms of paying for it in data, you were just talking earlier about the content creators being able to be on YouTube. That's definitely not the story that we're hearing from content creators. We're hearing that you can't make a living as a musician or a writer anymore. That, the way that content is now viewed as free means that there's no support for creation of content anymore. And so that's another way that as a consumer, I'm paying for it. Like, I'm paying because I don't have that book that I would have otherwise had, or the music that I otherwise would have had. So I guess I just want to push back on this notion of it being free. Maybe we're not, and I guess I just want to see what you guys think about that. I mean, can you look at data as a cost that consumers are paying?
And again, this was a lot of these points were brought up yesterday in the conference. So unfortunately, obviously, we weren't able to.
I actually say it is free with respect to financial contribution. That's true, and the fact that you are advertised to is a well-established business model. Broadcast television, in that sense, isn't really free because they advertise to you. The periodicals that you pick up on the subway aren't really free because they're advertising to you. Yeah, and so that's true. You're allowing yourself to be advertised to, and if
I'm not worried about the advertised too. I'm worried about the taking the tracking from me.
yeah, like Nielsen data,
like
right? Yeah.
broadcast-
So if there were a substantial market for paying for the service, and in some places there are, right? We have both broadcast and pay television, which is also tracked with stats. But where we do sometimes see markets for both. In some areas, we only see markets for one. For one or the other, but yeah, I guess if and frankly, I'm certain there are some. Our institution pays a premium to a number of cloud service providers to get enterprise level support for services that actually are free, because we want additional features that aren't made available over the top for the basic service. The same way you can pay. I don't pay for the LinkedIn premium service, but I know some of my colleagues do. They get some additional benefits, right? Basically, the markets kind of figure out what people want.
Yeah, and if I could just touch on the notion that you can't get that book you want anymore. According to pretty much every measure, in every area of artistic endeavor, in music, in books, and whatever, there is more being produced today than ever before.
That was just roundly refuted yesterday.
But just think of it. Just like logic.
Well, it's a difference between amateur production and professional production. There are just so many different ways to measure this. It's kind of hard to say.
I don't think that's not a relevant measure, right? When Justin Bieber started putting his videos up on YouTube because he couldn't get a record label deal, that was amateur. Right? How do you even define it? There is more music being made today than ever before, and listened to than ever before, in more places than ever before. And these platforms like Pandora and YouTube are paying the record labels billions of dollars in new income. So if you assume that as the Constitution says, the purpose of copyright law is to promote the progress of science and the useful arts, it's working. And it's working because we have a legal system that allows it to do that. We have the DMCA, and we have protections from liability. But by any measure,
the measure that was used yesterday was the size of the music market. Went from I can't remember the exact number.
The size of the recorded music market. Yeah. So when we talk about sound
well, no,
recording,
so that's a measure. I mean, I just came up with a measure right now.
Consumer
but also
spending on music is
half.
Right.
It's half of what it was 5 years ago.
Depends on how you measure, right? Yeah. By some measures, there is more money coming into the entire music industry writ large than ever before, but it's just not going to the same players. Right? It's not going to the record labels. In some cases, it's going directly to musicians.
It's not going to the person. I mean, if you're going to have a market, doesn't the person who's creating?
Right, and according to the Department of Labor, there are more people now who list their occupation as independent musician. So again, I think all the numbers, anecdotally, you can say you can't get that book, but I don't think that's what the facts bear out.
The authors kind of uniformly say you can't make a living as a middle tier author anymore. I mean, you could be a best-selling author, or you could do a book on the side but otherwise there's not advances anymore. There's not quality.
Yes. So if you're a musician or an author, they just disagree with you. So I mean, if you don't care about the musician or the author and whether or not they have a professional career, and you're okay with amateur production, it seems like that would be. That's one way. That's one.
I would
that's
probably
one
care
type
about
of
the
way.
data, and in fact, there's some interesting data which suggests that self-published authors are making more money on average than authors who have arrangements with traditional publishers, right? In a lot of cases, the corporate enterprises that support individual actors are having a harder time making the value proposition to those guys, which is why we're seeing record labels losing money, even though consumer spending on music is up, because increasingly more of that spending is occurring through digital services where so-called amateur artists can get out, and more spending on live performances.
How many self-published books were read on this table in the last year?
Oh, The Martian.
Okay.
Highly recommend it. No, it's like if you like the movie, you'll love the book. The guy he couldn't get a book deal from a publisher, so he self-published it, and it's brilliant. And if you haven't read it, that's my recommendation for beach reading.
How many self-published books were read in the audience? Do you guys any raise a hand if you read a self-published book in the last year? All right, we got two. Can we take a question? Can we make a question from the audience here?
So, sorry about that. So one of the things that came up yesterday was a point from Gary Rebeck, where he brought up the IBM antitrust suit. I think it was in the 60s and 70s. And he said that suit, even though it was dropped, forced IBM to unbundle its software. Prior to the suit, IBM just gave away the software, and so nobody bought software because they just got it with the machines they bought from IBM. And this led to the creation of the American software industry. IBM, when they came out with the personal computer, instead of making their own software, licensed software from a little company called Microsoft, and spread out the creation of the personal computer among all sorts of different sectors. But the case was a loss, right? So DOJ, or at least I guess DOJ didn't get anything out of it, right, in the settlement, according to the framework that, well, they might lose the case, they might drop it. So I want to sort of challenge, do you consider that case a loss? Should DOJ have brought that kind of case? If so, what kinds of cases aren't being brought today that are inhibiting the creation of the next sort of great innovative space like the American software industry?
Yeah, I would add to this. Are there any bad monopolies? It sounds like or any bad dominant players. Sounds like there's some agreement up here that tech companies are great, but what about?
Well,
are there any?
I previously mentioned the Apple eBooks case. I thought if I were in charge of the DOJ, I would have supported that case. I think it was a reasonable one and properly brought. My association was, and my former firm was actually heavily involved in the Microsoft case, so I have some views about that. There is a counter narrative about the transition from mainframes to PCs and now to smartphones, which tracks the sort of disruptive innovation that what's really changing these markets is new entrants come in. IBM initially sort of dismissed PCs. The major PC players initially dismissed smartphones, only to subsequently be disrupted as those platforms took over. And I'm not saying that's the only narrative, but there is some sort of compelling aspects to that. If we held this panel 10 years ago, everybody here would be on laptops. I can see like one, maybe two Windows machines now in the room, and we're all looking at our mobile devices, which are not running, and statistically, I think I can comfortably say not running Microsoft. So there is also that narrative, this sort of Schumpeterian creative disruption, and again that's kind of the counterfactual, right? We don't know the but-for world, and maybe if the IBM case hadn't occurred, these things still would have happened. That being said, I'm not an antitrust history expert, but there was certainly a lot of merit to the IBM case, but I think positing that but for that, we wouldn't have had the modern computing economy is a somewhat tenuous argument to make.
Okay. Any other thoughts? No bad dominant firms out there.
Wait.
So the sort of good versus bad. Okay, so I'm going to push back on that, right? I mean, like being a monopolist is not an antitrust violation. Please, can we all agree on that one?
Yes.
Before I go further.
Use a dominant
And so,
position.
look, the issue here is are there durable monopolies? Okay, and that goes to entry, right? And we see in the Microsoft case there were durable entry barriers, and the DOJ successfully brought and won that case. And so that's the key question here. Not is there a good monopolist, a bad monopolist. It's like that's not the ultimate antitrust question, and entry is much more important in inquiry. And then I'm going to say, look, I think we're talking about the internet here, and we're all representing internet platforms. And we heard from the previous panel, and I know people sometimes roll their eyes and they see it as a little cliche. There's time will tell, but there are a lot of good sound reasons based in economic theory and in fact why the durable monopolies in the internet online are really, really tough to defend. And so I'd leave it at that. Are there other industries? I mean,
no DOJ cases out there that would unlock competition in any of these markets the way.
Well, I mean, that's hypothetical, right? But I think that,
presumes that
wait, hang on.
competition is locked.
Right. Also, I think the one thing that's really important for sound policy making here is that in the tech industry especially, leadership and market dominance is really ephemeral, right? And I can guarantee, the companies that you consider to be dominant today, in 5 years, 3 years, 2 years, who knows, right? So again, that is why one of the reasons that we have succeeded in a far greater way than any other country is because we have made good decisions, right? And we have a First Amendment that allows you to say whatever you want, and we have laws that protect online intermediaries, right? And we have had historically a light regulatory touch when it comes to antitrust, and that's our success is not a coincidence, it's not luck. It's because we made those decisions, and those decisions have proven, I think, to be the right ones.
Got maybe one last question here. Let's get it. We've got some. All right, here we've got a question for Felix up here. Oh, you don't have. Do you want to just ask it?
Yeah, just kind of piggybacking on some of what's been said. I hate to bring up yesterday again, but there was, I think, a consensus when you think about the next frontier of technological development. AI and the Internet of Things were kind of the two areas sort of looked at or talked about. And we've also talked on all the panels today, this notion of barriers to entry has kind of come up. So if we look at this like the next frontier, assuming you guys agree that those two areas are likely to be where we'll see the most disruptive innovation. I'm just curious, your thoughts aside from Google, Apple, Facebook, Amazon. It almost seems like there's maybe not a strong possibility that another, who would another entrant potentially be, especially given big data and sort of access. I know you can't look into a crystal ball, but.
One of the interesting, and just to add to this, one of the interesting questions from yesterday is that, okay, the issue is not that, one of the issues is that you use Google Maps, you don't have any access to their algorithm. They also own billboards. So when they are giving you directions, how can you be sure that you're getting the fastest route as opposed to the route that passes you through the highest number of Google-owned billboards in the future? And obviously that has to do with AI as well. So if you have no transparency and no auditing process and things like that for these algorithms, and how can you be sure that you're getting what you want? And added to this was that Facebook controls their algorithm to hurt specific types of news providers and
Okay,
promote others.
that was alleged, and I think if you're going to point out that it was alleged, you should also point out that Facebook denied the allegation, right? So we have two competing allegations. I think parties can disagree as to what the right one is, but if you're going to say it was alleged that the moon landing was staged, I think you should also say that NASA alleges that it actually happened.
No, I don't think it's alleged that they boost like BBC and things like that in their news feeds. So fine, the conservative news thing you can allege, but it's
Actually,
not.
I'd like to answer both those questions. I don't want to, but I want to let Michael get a word in edgewise too.
Well, first of all, because there's a market, and I have at least 3 map apps on my phone, and if one of them keeps on directing me to traffic jams so I could see a specific billboard, then I will very quickly use another one.
Do you have any
There's a marketplace.
Do you have a
and it works.
non-Google on
Yeah.
map app?
Yeah,
Okay.
there are tons of them.
Actually,
can I add something here too, just to take a step back? So we're talking about consumer welfare, and you're positing a question, Teddy, about so algorithms and Google Maps, and just asking people to take a step back and say, imagine a world without Google Maps, right? And as consumers, consumer welfare being an important issue here, we benefit from the consumer surplus that the internet delivers to us every day in ways we don't even notice because they've become so ubiquitous in our lives. And that's real dollars. That's a pocketbook issue. And that number is in the billions of dollars every year. And it's not just from Google Maps. It's from, every time we access and use the internet, the time and money that we save, lower transaction costs and time saved is a really overwhelming number. And so I wouldn't want to lose sight of that in this context either. So.
Yeah, there was a map app that was taking a share from Google. It was called Waze, and then they bought it.
Yeah, so actually,
there are many map
Can I
apps.
make a product endorsement for there's a great offline map product called Maps.me, which I love. It's good for particularly traveling abroad where map services aren't very good. So that's one I recommend to anybody who's going abroad. Just check it out in the App Store. I have no financial interest in this product. I want to talk about IoT because, by the way, and if any of these map services are saying this is the fastest route to get from point A to point B, and that is not in fact the case, and they're instead routing you by their properties, I think that's a slam dunk Section 5 case. No, that is not.
But how would you know?
Well, how do you know that you'd be comparing it to other services, for example? But essentially, we have very liberal discovery laws in this country. If you can make the
Right. Right. Right.
How would
Yeah.
you know that? How would
Right,
you, I mean,
and
I
also
agree.
the-
I'm not saying it's happening. I'm just saying you would have no idea if it told you that the route going by the billboard was the fastest one.
But if you were using a map app and it consistently underperformed, you would switch to a different map app, of which there are many. And again, as Abigail was saying, just also imagine the upsides, imagine the benefits. Imagine if you were in a large metropolitan area where they decided to shut down the entire metro for a summer. And imagine you didn't have a map app. Like, what would you do? What would you
Yelp-
do? And it's
keep-
an insane hypothetical, but just imagine.
You keep mentioning Yelp, and Yelp, how great Yelp is. And Yelp, Tim Wu did this study saying that, Google systematically worsens their own search engine to prohibit competition and from vertical search. So they're worsening their service in one way, and it just.
This is not. You don't have to guess about this. Uber was caught misrepresenting the time it took for Uber drivers to reach your. They put maps up on your phone showing 2 minutes away, 3 minutes away. It wasn't true. They were caught. I didn't see a Section 5 case brought. I didn't see people switching. This is not hypothetical.
All right, I am not alleging that every Section 5 case that can be brought will be brought, but I think that would that is
But it would be a
viable.
slam dunk. This should be a slam dunk.
It should
So
be,
FTC,
and the
anyone
fact
here.
that the fact that enforcers aren't bringing it might suggest a resource priority issue. And also, I mean, I would be very surprised if you didn't find a state class action law under 17200 being filed in
If I can
California.
add, they're also misrepresenting the size of the cars. They are not actually 20 feet long. It's very important.
But can I-
That's an interesting point because FTC did go out of its way to scold local regulators for any rules that prohibited Uber from entering a market. So they seem to be very.
So if that class action,
aware of that, yeah.
if that class action hasn't been brought, there's probably an opportunity there. But I briefly want to say, I think one of the leading IoT platforms that's out is not a platform that anybody's heard of. It's actually a Samsung owned product called SmartThings. It was a startup here in DC. They recently acquired them, and they were an upstart that basically got into the marketplace using open protocols and built an amazing software platform. I'm a user. I think it's amazing. And they were a startup right now. Samsung came in and acquired them. So I guess now you have to add Samsung to the list of the platforms. But the interesting thing really is that right now where the marketplace is I see them at the risk of being disrupted by a somewhat accidental product from Amazon, which is their Echo. So there is an incredibly dynamic marketplace right now in IoT, at least in the home environment, and it's quite frankly anybody's game, and some of those anybody's could be platforms you haven't even heard of.
Well, I want to thank all of our panelists. It was a great conversation.